Okay. All right. All right. All right. So I did a mic check earlier, so I think that works fine. And now a camera check, and I think that looks to be working fine also. Um, Housekeeping. So a couple of housekeeping pieces. I'm expecting more people to show up throughout the class. I'm going to start with the Q&A just so that, oh, I can't hear you. How's my volume? Somebody can't hear me. Okay, I got a couple of thumbs up. You hear me now? Good. Good, good, good. So yeah, I like to be interactive. So in a classroom setting, we might even start with the Q&A, right? Mainly because you'll have the slide deck. That's yours, right? So I don't want to read that to you. Instead, I like to see what issues you guys are seeing out there, so that we can answer some of those up front. 99% of the time, I've seen that in the process of doing that, I'm actually talking through what's in the slides. So I've been known to spend the first hour and a half of the class just as a Q&A. And I put Q&A in air quotes because it's really just an interactive conversation that we're using to deliver the topic. And then we'll spend the last few minutes kind of reading through the slides and pointing out a lot of the things that we've already covered in our conversation. A lot of times in life, in real, I guess they call it IRL, in real life, half the people that sign up don't show up. I was thinking there'd be a lot of a bigger turnout for the people that signed for Zoom that actually show up, but it looked like it might be about the same. So, but the people will keep trickling in, I'm sure. So, again, housekeeping rules. Feel free to stay off mute unless you got background noises. But I do want us to be interactive, and so you interrupt me as often as needed. If you need CE credits, please do make sure to put your CE, your license number rather, in the chat box. Let me check something else here real quick, and then we'll get rocking and rolling. How's my screen? Can everybody see my screen okay? Let me make sure I'm seeing the thumbs ups here. Nice. So you see the mediation dispute nice. Okay. There we go. Everybody's trickling in. So we give it another 40, 60 seconds and we'll get rocking and rolling. Okay. So yeah, mediation, dispute, conflicts, big part of life. So we figured out how to uh, present this in a format that fits the real estate commission's requirement as a CE course. So everybody in attendance will get 2 CE hours. Um, so we got to we presented this curriculum to Trek some years ago, and it was approved primarily because of the way we use mediation in real estate. By design, our Trek contracts are they have a mandatory mediation clause, right? And so in the past, we've 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 had to learn, if you will, because a lot of people might think that mediation is is still more litigious than it is, or they might think, man, mediation is just kind of rolling over and not getting not getting your way, if you will. And we'll cover all of that because a little bit of both is true, right? In any mediation, there's probably a whole lot of compromise involved, right? But at the end of the day, it's one of those things that there's enough value in it that the statutes and the law will sometimes actually require you, even if you have all the rights to go to a courtroom, the statute will probably require you to go through mediation first, see if you can resolve the issue. And if not, then you can't come to court. So again, name's Damon. I'm a real estate broker. Grew up in real estate. I've been in real estate since I was a kid. Of course, as a kid, hated it because that meant kind of tagging along with dad and doing all the things that he didn't want to do, like mowing the lawns and polishing. Back then, the houses had lots of mirrors, right? And so we were always polishing the mirrors and making sure the fingerprints were taken off the mirrors. But as an adult, it was a no-brainer. I got into real estate in my early 20s and haven't looked back. In 2009, took a break and went to law school. Okay, took a break, went to law school, and within the first year or so of law school, I realized that I didn't want to be an attorney. And show of hands, anybody know difference between the attorney and the lawyer? I always like asking that question because as a society, we use them interchangeably, right? But the attorney is the person that represents you in court, right? So compared to a lawyer has a law degree, whether from California, China, or Oklahoma. Until they go take the state's bar where they want to practice, they're a lawyer. And then the attorney is actually barred, if you will, licensed in that state to represent people. So early on, decided that I didn't want to be an attorney. Luckily, I was in a position to do a joint degree where where I did an MBA and a law degree. And what that has done for me as far as my career is put me in a position where 99% of the time I'd rather wear that business hat. Even when people ask me legal questions, I usually rephrase it as a business question and find a solution that way. Of course, occasionally there's the scenarios where there's no other way but to just have to deal with it from a legal angle, in which case then we'll get the attorney, right? So a divorce attorney would be different than a contracts attorney, for example. So when it's a strictly legal issue, then we get the attorney that's the most applicable for the issue. So I have a law degree. I prefer business because business by design, we're always talking about business and so let's find a win-win scenario. Where in law, I think a lot of times you end up in the adversarial I win, you lose position. And it's just a lot more facilitative to find a win-win situation than to try to litigate certain things. So I have a brokerage. One of my things with the real estate industry is just trying to keep up with the changing times. I think a lot of it is still a little bit archaic, dated, if you will. Um, and we could see the shift as NAR and everybody else is trying to figure out how to deal with the lawsuit that happened a few years ago. It's only a matter of time before we have to shift the real estate industry into something different than what it was, at least when I started. So, with that said, there's just the right amount of people here. Usually, when there's too many of us, I will skip this part, but let's use this real quick as roll call, right? Because Trek does want me to make sure that people showed up before they got the credit. So, if you don't mind, I'll try to run through us alphabetically. And if you could just kind of answer, say your name, put your license number in the chat box. If you know your license number off head, you can say it in your introduction. And then tell me kind of what's your niche? What do you do in real estate? And then where you operate from, whether it's locally, statewide, nationally. And then the main thing that you'd like to take away from today's conversation. So let me start with All right. So I'm just gonna go through the list the way it shows up on my list here. I got Jan Berry.
Yes, sir. Can you hear me?
Yes.
Yes. I'm a broker. I have several offices I have one in Amarillo, Abilene, and then in Comanche, Texas.
Okay.
Just today, just wanting to learn a little bit about, you know, just more education.
Okay. In the right place. Do you happen to have your broker's number memorized or no?
Yes. I put it in the chat, but it's 557-947.
557947.
Yes, sir.
I've been around long enough to know that the fours and the threes, kind of the year that they are. So I know the fives is probably what mid 2000s, well that's 2004, 2005,
2003.
2003. Nice, nice,
Yep. I've been in this job. Well, it's actually 23 years
nice.
on March 6th.
Celebrating an anniversary. That's always good to hear. And I'd like to ask the numbers. It's an honor. I know that I've seen a couple of fours, a couple of license numbers that start with the four. So anytime I get a chance to present to people that have been doing this longer than I have, it's always an honor. I had a couple, actually, husband and wife, real estate team, and their license started with the one. They were in one of my classes earlier this year, and I felt like I had access to the Library of Congress because they were so knowledgeable. So I might tag you in throughout the conversation just to have you share some of that 23 years of experience. Kathy, is it Kathy
Yes,
Richard?
yes, I'm here. Can you hear me?
Awesome. Yes, yes.
Okay. Um, well, I put my license number in the chat, but it's 376-266. I've been in real estate 38 years.
Wow.
Um, and the reason why I'm taking this class, let's see, I owned a Remax office for 15 years. I sold
Yeah.
it and now I'm just a Remax agent. But I'm also on the Professional Standards Committee at Texas Realtor. I've
Nice.
been doing mediations and ethics hearings for them for, I don't know, 10 years. I also went to UT Law School to become a certified mediator, and I absolutely love mediation. And I know there's
Good.
always changes and there's updates. So I really wanted to take this class for that reason.
Glad to have you. Glad to have you. Okay, let me
Thank you.
see. Glover Wilcher, was it Omri?
Yes. Hi, how you doing?
Pretty good. How are you doing?
I'm doing good. I am Amory Wilcher. I'm in the Dallas area, August Square Real Estate. Been doing this for 5 years, part-time,
Okay.
mainly lease, but I'm starting to get into the buyers as far as being a buyer's agent. And I just want to get some ins and outs of the mediation. Of course, I hear stories and stuff like that, but just actually hearing it from someone, just getting some education on it. I can't hear you, sir.
Uh-oh.
Okay, I can hear you now. When you
Can you
said,
hear me
"Oh,
now?
yes."
Yes. Awesome. Awesome. Yeah, I feel like I was kind of just going through that roll call mode. So I was asking for Bertha. I think you're still on mute.
There you go. Hi, my name is Berta Norzagaray. We have a company here in El Paso. My daughter Bianca Urias is in the on the Zoom too. She worked with us, and we are a family company from since 2019. We had property management around 140 properties here and in San
Oh, wow.
Antonio area. And obviously the sales area, BNB Real Estate Group, here in El Paso. My broker is Ruben Schaefer, and he's like about 50 years of experience as
Oh,
a broker.
wow.
And is a third generation as a broker.
That's awesome.
Yeah.
That's awesome. That's
Nice to meet
awesome.
you.
Absolutely. And then you said Bianca is also with you?
Yes.
Okay. Let me see here. Yeah. About Cheryl?
Hi.
Hello.
Hi, I'm Cheryl Wheeler. I'm in the Katy area. I work for Remax Single Ranch for, well, my license begins with a 4, and
Nice.
I've been there about that long too. And today I would like to just further my education. The real estate industry is becoming a landmine to
Yes, yes,
navigate. So I'm interested in learning all I can.
yes, yes,
Always.
yes. I like that you called it a landmine. We'll share some of those war stories here in a little bit. Yes, yes. Okay. Elizabeth?
Yes, it's me. My name
Okay,
is
awesome.
Elizabeth Correa. Good morning. My license number is 0640449. I've been a real estate agent since 2014. And the main thing I want to learn today is I just want more information. I just received a letter from an attorney. This is all new to me. So
Oh
it's
no.
kind of scary. I don't know how to handle it. So I'm just trying to gather as much information as I can.
Okay. Sorry for the letter. Those tend to cause sleepless nights. Um,
Yes.
yes, yes, yes. Hopefully we'll be able to kind of help you think through it. Of course, you'll see that at the end, we're quick to our lawyers make us put a disclaimer that we're not here to do legal services today. But we
Oh,
will do our best to just kind of talk about the facts of your scenario and see what we're able to shed some light on.
yes, yes, I know. I just want to have more knowledge about how to handle these things. It's like Cheryl said, it's a land mine
Landmine.
land. Yeah, so it's scary, but I think when you have like a bit more knowledge about how to handle things, it's easier. So I already talked
Yes,
to some attorneys and lawyers, but I just want to do my part on my end.
absolutely, absolutely. And we got Jackie.
Hello, I am Jackie McDonald. My niche is high conflict divorce real estate. So I do a lot
Okay.
of receiver work in the local district court. I am Ellis County, so South DFW, Waxahachie, Midlothian area. And I'm just always looking for more education on dealing with high conflict situations.
Awesome. In the right place. And I think we have two Kimberlys. Gamble.
Yes. My name is Kimberly Gamble, and my broker number is 512321. And my niche in real estate is primarily investment and landlord tenant. I do a lot of that. There's been some use of mediation in some of the, eviction kind of cases and things like that. And I'm just trying to get a little bit more insight on that. And I operate primarily in the Houston area, and a few of the surrounding kind of suburbs, but mostly Houston. And as I
Okay.
said before, the main thing that I want to learn today is the use of mediation with kind of in those situations, and just get some pointers on how to be more, I guess, understanding of the process and effective.
Okay. Good. 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 The right place. And then the next Kimberly is Martin.
Hi, I'm Kimberly Martin, license number 0506865. I earned my salesman's license in 2001 and my broker's license in 2007. And I got into real estate because my dad owned a home investor franchise. So I worked with investors.
Nice.
I represented landlords primarily. And I had 7 broker licenses for different states for a while. I'm kind of semi-retired now.
Good for you.
Yeah, I'm helping protest property taxes now. I just started my first year with the TAR Professional Standards Committee. So
Okay.
Kathy, I'm looking forward. Is it Kathy or did I get it wrong? She's on there. I'm looking forward to learning more about that. That was another reason for the mediation class, is because of the professional standards.
Yes, 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 yes. Now the home investors, with that, I remember saying that we buy ugly homes.
I used to have Dad's bobblehead. I don't know where it is anymore.
That's awesome. Home investors. Yeah. Awesome, yeah. Awesome, awesome. Then I think I got was it Linda?
Hi there. My name is Londa Salazar, and my niche is really just single family land and farm and ranch. I'm in Ellis County and Johnson County. I'm just here today to learn whatever you've got. So
Okay.
I've actually had the flu for like a day, so I literally got out of bed to come to this class. So
bless your heart.
I know.
Well, you don't look like you have the flu, but I'm glad that it's via Zoom, so that it's not a super spreader event.
Right.
Yeah. Well, cool. And then we have Sonia.
Yes, Sanja Tejada. I'm with August Gray Real Estate in the southwest area of Dallas-Fort Worth. My license number is 655898. And I'm just here to kind of understand more about the mediation process, the details, kind of the logistics of it.
Okay. Awesome. Awesome. Thanks, everybody. I think I got everybody. If I didn't get you, now's a good time to pick up. But regardless, I think the main thing is do add your number to the chat box, and we'll make sure that you get the 2 hours after the course. Okay. Nice. So our goal today is to basically go over how the real estate industry, right, benefits from mediation, right? At the end of the day, disputes is inevitable, right? Especially when so many dollars are involved. I think the average, well, I'm not sure if they call it average or median anymore, but the median price point in Texas is probably, $400,000. So by the time you do 3 deals, you've touched more than $1 million of somebody's money, right? Oh, I see here Bianca wasn't called. Go ahead, Bianca. Let me get you down to make sure you have your CE. Bianca, you want to introduce yourself real quick? Okay. So I got you down, Bianca. Like I was saying, by the time you do 3 deals, you've touched $1.2 million of other people's money, right? And we know how people get a little sensitive, if you will, when it comes to their money. So it's inevitable. And part of what we do, if a property gets tied up in litigation, it pretty much stops everything, right? So whether it's because of a construction issue or whether it's because of a disclosure issue, whatever it might be, our goal is to introduce the idea of using how to use, we'll call it alternative dispute resolution, right? And I want to take a minute during the terminology to help us understand the difference between arbitration and mediation, right? And when we do that, I'll use Judge Judy, right, as an example to help us have a better understanding of the difference between the two. Okay. So paragraph 16 of our contracts required, right? It's the policy of the state of Texas to encourage resolution through ADR, right? And when I say ADR, alternative dispute resolution, I'll use ADR quite a bit during this conversation. I myself, I'm a mediator, and so I'm a big fan of it. So anything that I say that seems like I'm over confident about mediation, take it with a grain of salt. But yes, I'm a big fan of it. Okay. But paragraph 16 says any issues, right, between seller and buyer related to this contract that's not resolved through informal discussion. So the idea is, look, talk about it. And if conversation doesn't resolve the issue, then it will be submitted to a mutually acceptable mediation service provider. And of course, the last paragraph then says this paragraph does not preclude a party from seeking equitable relief from a court of competent jurisdiction. Most judges will require you to go in and do a mediation before they'll let you come into the courtroom, right? So it's not saying that you can't go to court. It's just saying try this conversation first. Try conversation, and if the conversation doesn't work, have a neutral party, a mediator, hear out the facts, hear out it's usually a lot of emotions. At the end of the day, that's one of the things that mediation brings to the table that you don't get to deal with in court. In mediation, there's a 5-step process, and we'll go through that here in a little bit. But during the 5-step process, like the first 2 steps are just about getting the emotions out of the way, right? Giving each party a chance to talk through why we're here. And a lot of it will be that they're upset or angry or whatever that emotional word will be because of what was done or what wasn't done in some cases. Okay, so let's get into the terminology of it. And like I said, I'm a big fan of interactive conversations. So before we get into the terminology, I almost want to start with a Q&A, right? But before I do that, let me see if I can help us differentiate between a mediation and an arbitration. Okay. If you file a lawsuit, okay, you don't get to choose which court you're going to file the lawsuit in because there's certain statutes that that dictate where you can sue somebody. Okay, so typical lawsuit, you don't get to decide where or who the judge will be. It's just based on jurisdiction wherever you're at. So in arbitration, Judge Judy, right? Even though she goes by Judge Judy, she's actually wearing a arbitrator's hat during those sessions, right? We call it Judge Judy because she used to be a judge. And for the most part, as a society, we've all agreed that once a judge, always a judge, okay? So Judge Judy is not wearing a judge hat during her show. She's an arbitrator. And the main thing there is the parties in front of her chose her, right? They didn't have to go to the specific court in their jurisdiction for this issue. Both parties, somewhere along the lines, agreed that it's Judge Judy that's going to hear their case, right? And basically bind, right? So she has a binding decision. Whatever Judge Judy says goes. It's binding, okay? And because she's arbitrating, she doesn't have to rely strictly on the law, okay? In fact, she really doesn't have to rely on the law. And that's why she gets away with a lot of the different things she said. Like, shut up, this is my courtroom. Nobody else matters but me, right? Because she's an arbitrator. Now,
Your sound went off.
I know.
let me know when I'm back.
You're back.
I'm
hear
back.
you.
All right. Seems like it does that every few minutes here. So yeah, please let me know if my sound ever go off. But I think I'm hoping that the last thing you heard was I was saying that Judge Judy is an arbitrator. She doesn't have to apply strictly. She doesn't have to strictly apply the law, right? But of course, the better she does at understanding the facts of the case or the issues and resolve the parties, the more likely people will come back to her in the future, right? So the mediator, on the other hand, right? So we've talked about, litigating in front of a judge, right? Parties don't get to choose who the judge will be. Parties don't get to choose the location. It's a statutory situation in that scenario. We've talked about arbitration. That's the typical judge shows that we see on TV. Most of those are arbitrators. Even though they call themselves judge, it's likely because they used to be judge, so we still call them a judge. And in that scenario, the parties get to choose who will be the arbitrator. The parties get to choose a location for the most part, or maybe the arbitrator would choose a location. But it's all, those things are fairly negotiable. And then the cost is just borne by the parties, usually equally. Then the third scenario, most of what we'll be talking about today, is the mediator. Similar to an arbitrator, the parties get to pick the mediator, okay? The mediator doesn't get to hear, the mediator doesn't apply any law at all, and the mediator's decision isn't binding. So what the mediator do is just facilitate a safe environment for a conversation, okay? Mediator is a third-party neutral, right? That helps the parties reach a mutual acceptable agreement. Mediator doesn't get to influence their decision, right? It's very important that we stay neutral when we're in front of disputing parties, because otherwise one side might feel like we are picking sides. So that's the biggest difference between those three scenarios. So now that we've done that first definition, let's really talk through some of the Q&A stuff that you guys might have, because I have several more slides of terminology. I could start reading it to you, but I don't. I think our time would be better used just kind of having a round table type conversation. And I'll start by saying, there was a statement earlier about the landmines, right? There was a recent case that came across my desk. It was actually in a class similar to this. And the lady was saying that she sold a house, she represented the buyer 3 years ago. There's a statute of limitation that says if you want to sue somebody about most things, it's a 3-year statute of limitations, right? Depending on what the issue is, the statute of limitations will be different. But in this scenario, it was 3 years. And about 2 weeks before the statute of limitations would have ended, her client calls and says, "Hey, you did great, but I'm gonna go ahead and file a lawsuit against your E&O, right? Because I understand how E&Os work, and I hope to get some money back for my, I think it was a septic tank issue, right? Hey, my septic tank issue, I'm just gonna go ahead and file an E&O claim and so on and so forth." So the issue wasn't, the guy lost, by the way, right? So the issue wasn't that the agent did it wrong, it's just that the individual understood the terrain and understood that E&Os are there to help, I guess, write checks. Okay, so that was a scenario that came across our desk, and studies are now showing that a lot of septic issues is one of the most litigated issues in real estate. Okay, it just is, because by design nobody wants to deal with the proverbial shit tank, right? It's there. We know it's there. I want to flush the toilet. I want it to go away. And if and when it doesn't, it's a big problem. So those are some of the issues that we're seeing quite a bit. Scenario, buyer's is not upset about the transaction. He just wants his septic tank replaced, and so files a suit against the agent's E&O insurance. And the agent didn't quite understand mediation well enough that she was like, no, 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 I know I'm right. I'm going to go fight the right fight. And that's what I call it, right? When somebody's in front of me and they're like, no, 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 I'm ready to fight the right fight, right? That's a term that we use because they don't want to compromise anything. They don't want to have a conversation, right? They don't want to reach a mutual acceptable agreement. They want to pound the other side because they felt very wronged. So what other kind of fights are you guys seeing out there? I know the young lady that says she has one in front of her right now. This would be a good time. Share a little bit about what it is, kind of what happened. And I'll encourage anybody else that might have been sued in the past or that is going through a scenario right now. This is a good time to kind of talk through it, and let's see if we can make some sense of it.
Well, basically, I sold my property in September, October last year, with the lease back ending in January 31st. Okay. So I left the house super clean and everything was good inside. But we left my husband left some trash on the backyard. So I think that's it. That was it.
Oh, wow.
Just received a letter saying that I steal some pottery, that I have to fix the railing, that I have to pay for a new Ring camera.
Okay, camera. Wow.
Yes, and somehow this lady is saying that I remove a electrical post, temporary electrical post, and I cause damage to the lawn, and I have to fix that. And yeah, They kept the deposit and they are asking for more money, way more money than that.
Wow. Wow. When the economy is bad, I think it's safe to say that the economy isn't as strong as we all want it to be. When the economy is bad, we see a lot more scenarios like that, a lot more litigations. I'm kind of a legal nerd, and so October last year, I think that was the month that we had that long government shutdown, the longest one yet, right? So during that shutdown, like nobody was getting paid as far as people that were relying on payments from governments, right? So I don't think they call them food stamps anymore, but it's always going to be food stamps in my book. But that wasn't getting distributed, okay? So one of the things that I noticed that happened, and I'll tie this back into what you were saying just now, Elizabeth. Well, one of the things that I noticed that happened is Smuckers, the big company, Smuckers, that make the peanut butter and jelly stuff, right? Sued Trader Joe's because Trader Joe's has a product that looks a lot like its product, okay? And part of what was happening during that time is people were more inclined to buy generic products, period, right? My dollar is not going as far as it used to. I want to buy the generic store brand. And so a lot of these name brand companies, right, are seeing their sales declining. Okay. So Smuckers sues Trader Joe's because its peanut butter sandwich looks a lot like its, and they basically say, hey, you're copying my product, and I want you to not only take them all off your shelf, but I want you to send them to me so that I can destroy them. Right? That's what Smuckers told Trader Joe's. I thought it was funny. I chuckled at it. I didn't keep up to see exactly how it ended, but I'm sure they probably ended up settling something in a mediation. Okay, so I use that scenario to say even Smuckers felt the pinch of the economy enough to say, hey, enough with that off-brand, store brand stuff. You're taking money off my table. Okay, so when it comes to just regular everyday people, part of what we see a lot of times is whether maybe somebody got fired, right? So the guy that did the septic I was just talking about, not sure exactly what happened in his life financially, but he needed some money. So he said, yeah, I'll call the E&O and see if I can get some coins from that scenario, right? That's really what it boiled down to, right? Whether it was because of love or just some bad financial decisions, who knows? And so in your scenario, I wouldn't be surprised if that's part of it, right? It's like, yep, we could use a couple of $1,000s to pay down this mortgage or whatever the case may be. And so let's see how far we can get by sending this lawsuit. If we ask for $20,000, maybe we'll end up with five, you know? But in that scenario, I think what usually ends up happening is cooler heads prevail. Okay, so as much as you want to go lawyer up and run back to the courthouse to go do all of this defense and pieces, nothing against your attorney showing up, but recommend, hey, look, this contract is governed by mediation. Let's sit through it. One of the good things about the mediation scenario is by statute, and anytime I say statute, that's just another word for by law, like it's in the books. It's confidential, right? Nothing you say in a mediation can be carried forward and used against you. It's prohibited, right? As a public policy, we as a society want less people clogging up the courtroom doors, right? So that's why the state, that's why the government, that's why the laws got enacted to say we want to encourage mediation. Thereby, we will make sure that nothing that's said in that room can be used later on in the court, right? In fact, most of the time, what is said in that room will probably help one side see how kind of bad, I don't want to use the word bad, but how weak their case is. It sounded good in their head, and they're like, yeah, you know, one person asked a couple of weeks ago, was like, well, what if I have I forgot the word, but almost like a bulletproof case. And I was like, no, there's no such thing in the law, right? Because both sides usually think that, you know? And one of the things that got me early on not wanting to be daily in the law is sometimes the wrong person wins. A lot of time, you know, especially as you read certain fact patterns. You know, you read the first 10 pages and you swear grandma's gonna win, and then like on page 12 grandma loses because of some technicality. It's way too often. Okay, so there's really no such thing as an ironclad or bulletproof case. So it makes more sense to just figure out how do we find an off ramp, right? One, how do we minimize the sleepless nights? How do we make sure that none of this is going to affect the transactions that we got going on? And find an off ramp while keeping it all confidential, right? Because that's what the system wants from us. Another thing that a lot of people don't usually get is, as a society, we like apologies. Okay, we encourage apologies. If I pull out of my driveway and I hit the neighbor's dog, and I get out and I'm like, oh my goodness, I am so sorry. The neighbor doesn't get to say, well, he said he's sorry, so that's liability. No, because the system, right? The law wants me to apologize so that my neighbor doesn't lose his or her temper completely, right? So apologies are not admissible. Again, I'm not giving legal advice, just kind of talking through what mediation looks like, right? Apologies are not admissible. Just like if after I apologize, I run straight to the tire shop and go buy some new tires or new brakes, because that was part of the reason why I didn't stop fast enough, is because I had bad brakes. That's not admissible, because we want to encourage people fixing their brakes, fixing their tires, instead of just to keep using it because we think that's going to show liability. So I said that to say a lot of the things that we usually think shows guilt or liability is usually not that. We actually encourage it, right? We actually encourage it to say, if you find yourself in this situation, do X, Y, Z to mitigate any kind of damages that might come out of it, right? So yeah, Elizabeth, I think what it sounds like is you find yourself in kind of in the crosshairs, right? Where somebody sees a target. And you said it, look, we might have left a thing or two, whatever the case is, it's definitely not up to this dollar amount that they're asking for, right? So in a mediation setting, it's a matter of, hey, look, whatever I'm gonna go spend on an attorney to go litigate this, I'd rather give you some of that just to make it go away today so we can all get back to life, okay? And it's not that you're saying I'm admitting guilt, it's just saying I just don't want to miss work. I don't want to miss any more sleep, right? I don't want to have to get back on my blood pressure medicine. Like a lot of different things that will affect why you would say, I don't want this fight. Not because I can't win it, but I don't need it in my life. You know, my spouse is already, our relationship is already on the rocks. Is that a question? Right? So it might be the head. my relationship is already on the rocks with my kids, my spouse, and I don't need this adding to that craziness. And so for that reason, I like the idea of sitting down and seeing if we can get this thing hashed out within a half a day, or maybe it's a whole day. Whatever the case is, the mediator will get to help you navigate that. Thoughts, feedback, questions?
So Damon,
Okay.
in that scenario that you're stating, you
Yes.
said they're going through, they're tired, they're frustrated, they really don't want that fight, and they admit guilt. So I'm assuming, at the standpoint of a Trek mediation, if they end up having to do a payout, doesn't that go on their record?
Yeah, so I don't know how Trek deals with the tri so Trek will usually call you, right, and say, hey, look, we got this problem, what's your position, right? But a well done mediation doesn't get to Trek. Because remember, everything that happens in that mediation was confidential, right? It's
Gotcha.
yeah, it is. It's confidential. I'm sure if Trek wanted to say, "Hey, how did it go?" then you guys can discuss it. But it's not a Trek problem unless somebody called and filed a complaint against you. So in the scenario where the guy's upset about the septic, right? He wasn't filing a complaint against Trek. He was just like, hey, I think you have good your insurance. You give me a new septic, right? So none of that ever ended up in front of Trek. And that's a good question because I think that's part of the reason why most people would be like, I don't want to deal with that, right? I don't want any glitches or any marks on my record. It didn't get to Trek, right? Somebody showed up, wants to sue you, sends you a lawsuit, right? Nothing with Trek. And you say, you know what, let's cool it down, let's get it some mediation and hopefully get it resolved before it goes any farther. Never gets to Trek. Never gets to Trek. But that's a good question.
Can I chime in?
Yes, please.
I think that every time I've worked on something like this, it seems like what you said earlier, it's an emotion. And I think the whole thing is getting to what the real reason
Issue.
is.
Yep.
He may be asking you for all these things, but that may not be the real issue. Maybe he felt wronged about something, or there's some underlying issue there. And I think if you request to do a mediation on this, you'll find, or the mediator would find out what the real situation is and maybe be able to resolve it with a lot less headache than what he's asking for. So there
Yep.
may be some underlying thing. Every time I've done this, it just seems like there's something else. And it feels so good when you find the underlying issue. So that might be why it would be best to do a mediation.
Yeah, thanks for sharing that. Thanks for sharing that. I just pulled up kind of the stages of the mediation. Okay, one of the first stages is where people just vent. Okay, so another quick story. Guy goes to get his oil changed. Okay, later on that day, engine blows up. Whatever, engine blows up. Okay, and of course, he calls the mechanic. He's like, hey, my engine blew up later on after I got my oil changed. Mechanic said, nope, it wasn't us. If your engine was going to blow up, it would have blown up while you were still in our parking lot. They go back and forth. Sooner or later, mechanic stops taking the guy's calls. Because like, look, why are you still calling? That wasn't us, right? And so the issue got in front. So then, of course, the car owner felt the need to go file a suit. And really, the problem was you stopped taking my call, right? So back to what Kathy said is like, look, I need to be heard. You can't just ignore me and think you can get away with it. So what I needed, right? The reason I filed this lawsuit is so that I can have my day in court, my day to be heard. Okay. So that's what a lot of these issues boil down to, is how do you make sure that both sides feel heard? Okay. So yes, a lot of times what we think is the issue is it's not, right? A lot of times I've seen family members get to the mediation and of course, because they're family, they don't want to stop their relationship. They're just unhappy about how you treated funeral or something, you know? And so then it's like, hey, I had no clue you felt that way. Right? That's one of the things that we hear a lot in mediations is I had no clue that you felt that way about what I was doing. I was just doing my best while dealing with the grief, right? But it looked to the other person as if you were doing not enough or more than you should have. So as we go through the different stages, we'll come back to that, and you'll get to see where stage one is all about setting the tone for the conversation, and then just letting each party talk about the past, what happened, and why we're here, right? And we'll go back and forth, right, until everybody has gotten the past out of their system. Okay. While they're talking about the past, we'll be listening for what exactly is it that you want again, right? And through the 5 stages, it changes. You know, where at the beginning of the conversation, the party, usually the plaintiff, might say, "Oh, I want $1,000," and then by stage 5, I'm like, "Well, you know what? Make it $700 and we'll call it a day." Right? It happens. And of course, there are some of those conversations where it doesn't get that low and they are stuck on the 10,000. We'll call that the right fight. I don't care what it takes. I don't want to settle for less than my $10,000. I'm ready for court. I think I can beat you in court. And I'm just here today because the court said we have to do a mediation. Okay. So we'll go through the 5 stages here in a little while. Let me see. I think I got some more chat here going on. Okay. Any other thoughts, comments? Those are some good comments right there. Okay, so then let me kind of run through the rest of the terminology. So neutral, impartial is what we do in mediation, right? We're not here to decide who's wrong, who's right. A lot of times, both sides usually have some kind of unclean hands, if you will. And so what the neutral third party is doing is just facilitating a conversation between the two people. Or it might be more. It might be 3 sets of people, right? Each person with their attorney. So it can get real convoluted real quick, but we usually try to limit it to where it's just the party, their attorney, and no more than 4 parties for a good mediation to really for a good mediator to facilitate a good mediation. Okay. Of course, the parties is going to be the people, the organizations, or entities involved in the dispute. So one of the words we use in mediation that's kind of unique is caucus, right? And it's just a fancy word for saying separate, right? If during the opening statement, I realize that these two are not going to be cordial, right? Or I feel like they might not be as open to having a conversation in the same room, then we separate them. And that's what we call a caucus, right? So it's a private confidential meeting between the mediator and one party. or that party's attorney, where I will then be shuffling between the two sides. Okay. And of course, the opposite of the caucus is the joint session, where all the parties are in the same room, whether virtual or not. Good faith just suggests that we're not here because the court said. Good faith say, I'm genuinely hoping for a resolution. Okay. Honestly, respectfully, and with a genuine intent to find a resolution, right? That's what we'll call a good faith mediation. Now, of course, we can all agree that confidentiality is that whatever information is shared during the mediation cannot be used outside the process unless agreed by all parties or required by law. Feel free to chime in, anybody. One of my favorite words in mediation is conciliatory, right? Conciliatory gestures. When I think of that word, I picture kind of that puppy that wants his belly rubbed, right? Looks totally different from the dog that's growling, okay? So a conciliatory gesture is when one of the parties makes a statement or does an action that shows a willingness to move toward resolution. And it might be very subtle, it might be as simple as, yeah, you're right, and that happens so fast, and it's just 2 words out of several hours, but that's a conciliatory gesture, right? Or if one party is not in agreement while the other party is talking, okay, it's not huge, but that's them showing, that'd be the opposite of them frowning, with their arms crossed or shaking their head no. So conciliatory gesture is one of those things that we're always looking for in a conversation. And so that when a good mediator sees it, they'll note that so that we can bring it up, whether later on in that phase or in the next phase, to say, hey, I saw that, you said X or you did this. Let's talk through that, so that we can find a common ground and a resolution to the scenario. So there's really 3 types. I like to say there's 3 types of mediations. My default will be the facilitative. Most mediations will be the facilitative, where the mediator is just focusing on communicating, clarifying issues, and helping the parties create a solution. Okay, that's 9 out of 10 times what we're doing as mediators. Facilitative. The other one is an evaluative, right? Where the mediator is being asked to provide opinions, assess the strengths and weaknesses of each side, and predict likely court outcomes. Okay, so if both parties have an attorney and the attorney hasn't had good luck communicating to their client that this is not a strong enough case, but their client just wants to kind of have that right fight, then the attorneys might say, hey, give us your opinion, assess the weaknesses here of our case or the strengths of it, and based on your experience in mediating, what do you think will be a likely court outcome, right? So that's an evaluative mediation, very rare, okay? The transformative mediation is fairly common for organizations, right? That's where you might bring in a mediator to your organization to say, hey, my marketing team and my engineering team are not seeing eye to eye, right? My sales team and my engineering team are at each other because the sales team is overpromising our clients in the deliverables from what, so the transformative mediation might might be designed to help us focus on communications and relationships within an organization, right? And it happens within families also, right? But just know that the default is usually just you're facilitating a conversation, right? Where you're helping the parties create their own solutions. So at the end of each mediation, the ultimate goal is a settlement agreement.
Hey, I'm in a class. Can I call you in a bit?
Okay, I love you.
Right? So the ultimate goal is a settlement agreement. Now, it's not promised because at the end of the day, in a mediation, both parties are there by their free will, right? Good faith, all of the words that we've already established. But if they can't come to a meeting of the minds, they don't have to agree on anything, right? They don't have to agree on anything. And so we hope for a settlement agreement, but it might be that at the end of it, nothing comes out of it. And we decide that, you know what, we're going to go take our chance in a courtroom and let the judge decide on who's right and who's wrong. My years of doing this and, you know, my background in the law, one of the things I like to say is it's hardly about who's right or who's wrong. It's usually more about who's righter and who's wronger. Because most of the time, both parties have a little bit of both, right?
Yeah.
Yeah, who's righter and who's wronger is usually what it boils down to. Okay. And of course, the MOU is just a written summary of agreed upon terms that can be later formalized into a binding agreement. In that evaluative scenario, we might come up with this acronym here, BATNA, Best Alternative to a Negotiated Agreement, which is just the parties looking at what's the best option that they have if mediation doesn't result in an agreement, right? So that's really them kind of with the crystal ball, right? Saying, hey, look, if I don't settle today, here's what I think is the best thing that can happen to me in the court, right? And of course, it's hardly ever that crystal clear. And of course, the opposite of that is WATNA, which is an acronym for the worst, right? The worst alternative to a negotiated agreement. Worst case scenario. Impasse. I'm sure we've all been here sooner or later in some of our transactions where parties reach a point where progress stalls and no agreement seems possible. So one of the strategies that I might use to overcome that is if we were all in the same room up to that point, then maybe we do a caucus, right? This would be a good time for us to separate into different rooms. And then as the mediator, I start going back and forth between the rooms to help the parties kind of pick up where they left off and say certain things that maybe they weren't willing to say in front of the other side. Another strategy when you have an impasse is just take a recess, right? Whether it's a snack break, whether it's a restroom break, whether it's just a break just because of the emotions and the energy needs to come down a little bit. Take a break, take a recess. Opening statement. That's the initial remarks made by the mediators or the parties to outline and set expectations for the mediation. During the opening statement, each side gets a chance to say why we're here uninterruptedly. And a good mediator at the end of it will usually follow up with anything else, right? Anything else, right? Because we want to get all of that out of the way opening statement so that we don't get to stage 3 and then somebody says, oh yeah, and by the way, if that happens, it's not a foul, it's just a good mediator would have done their part to get all of the past issues out during the opening statement. And each party will get a chance to have an unlimited amount of time, right? Within reason, but an unlimited amount of time for their opening statement to say, here's why I think we're here. One of the ways that I learned to do mediation years ago was to restate. It's called a restatement method, right? So that even though we're all in the same room, I tell the parties to talk to me rather than directly at each other. And the idea is party A tells me what the problem is, and then I'll restate it in a more neutral way. Even though party B or C are all in the same room and they could hear what was said, but I'll re-say it, right, in a more neutral way so that they can say, yeah, I guess that is a little bit less toxic, right? So a lot of that happens during the opening statement, where after the person makes their statement, I might come back and say, okay, so correct me if I'm wrong, but what I heard is A, B, C, D, E. And we usually have a lot more success with that restatement method than if we just let them loose and kind of go at each other. Okay, so shuffle diplomacy is what we call when the mediator is going back and forth between the separate rooms. And one of the main things that I want us to always remember about that scenario when the two parties are in separate rooms is one of the last questions that I'll ask before I leave a room to go communicate what was discussed to the other room is there anything that you just said that you're not ready to share with the other side? You know, so for example, while I'm in a caucus with one party, party A might say, you know, I just want this thing to be over. I'm willing to pay $10,000 for it to be over. Okay. But then when I say, hey, is there anything you don't want me to share? Be like, well, don't tell them we're willing to pay 10,000. Let's see what their number is first. Right. So even though I have an interest in getting the deal done, I don't get to go on the other side and say, hey, they got 10,000 on the table. Because before I left that room with the party that said they're willing to do 10,000, I'll make sure that we understand how much I'm authorized to disclose or what all I am authorized to disclose to the other side. So that's one of the things that why we call it shuttle diplomacy, is because we're going back and forth with terms between the parties. And then, of course, voluntary agreement just means it was reached by mutual choice, whether by force of a judge's order or an arbitrator's order. Enforceable. So the settlement agreement out of the mediation can be upheld in court if one party fails to follow through. Thoughts, questions, comments so far on the terms? I think that's the end of the terms terminology. Any feedback?
So your mediation report would be recorded with the judge if a payment schedule or is made out? Is that what you're saying? So that they could go forward with the judge?
Yes. Good question.
Is all mediation recorded with the judge?
No, just the agreement. Nothing else in the mediation. The judge doesn't want to know. The judge will probably, ask the mediator to stop mediating if more than just the agreement was disclosed, right? Because the law says that everything that happened in that room was confidential, even to the point where part of the opening statement is, hey, look, no recording, right? I can't take your phone away from you, but you can't record this conversation, right? Even the notes that we take, we recommend at the end of the conversation, whatever agreement we have is what you take away, but all the scribble, all the notes, it's designed to be destroyed at the end of the mediation.
I've
But
done
to,
eviction hearings and I worked with a mediator and it works, but then sometimes you get the tenant that's just like, nope, I want my day in court. And what's funny is they go before the judge and the judge says, this is about rent. If you can't pay rent, you've got to
can't
get
stay.
out.
You gotta
And we
go.
tried as mediator to give them a payment plan. They
Yep.
didn't want anything to do with it. It's funny.
It's crazy. It's crazy. To follow up on the statement you made, once you have an agreement, okay? So let's say 3 hours later, you guys, the parties agree on XYZ. As the mediator, I'm just a scribe. I don't get to ask party A or B, why would you make that kind of that sounds bad. I don't get to do any of that, right? I just write down what they agreed on. Now, I don't get to take that to the judge. It's up to them, right? It's up to them to go record it with the court. Okay? I can show them how to do it. I can help them navigate how to do it. But
Is that good to do that just so in case someone backs out of their end of the bargain?
Yeah. And because once you start entering stuff into a case, then you're a party, right? So don't go insert yourself into the case. One of the things that my mentor used to tell me back then was, don't get any of it on you. Like don't get any of the mediation on you, right? When the proverbial stuff hits the fan and you walk out of the room and you're covered in it, right? So it's like, no, don't get any of it on you. So yes, once it's documented that we agreed on XYZ, it's up to the parties to go record that in court. One of the things that I like to introduce, or I like to encourage people to do, is what I call EDR, which is early dispute resolution. Okay, 90-something% of the mediation happens because one party already made it to court, filed, and the court clerk or the judge said, before you come back and hear your case, go to mediation. So that in those cases, then yes, you need to take something back to the court to say, hey, we didn't settle, or B, we settled. But the EDR is when I say, look, before you guys get there, let's have a conversation, right? Before we can all see the tension is brewing, right? We can all see it's coming, it's inevitable. So kind of the eviction scenario. So to tell the tenant, hey, I'm about to go run to the court and do XYZ. Even though I know I'll probably win, I just don't want to waste the time and the energy, and I'd rather give you the cash for keys. Let's sit down in the mediation, right? If clearly you haven't paid me, so suggesting that you don't have any money. So what would it look like if I gave you X amount of dollars to give me the keys and get out of my life? So that's what I would call an EDR, early dispute resolution, in which case there's really no document to take back to the court. So that at the end of that agreement, at the end of that conversation, you have a contract between the two people, and it's just when the parties don't act on it, then you can basically, for lack of better terms, sue for a breach of contract.
Can I interject?
Yeah.
Can I,
Yeah, please.
Well, I will. The National Association of Realtors, in their mediation training, one thing that I learned that has been extremely helpful is that in real estate, and I would think in other kind of disputes as well, is that we want to make sure at the end of all of this that the parties if they're two realtors, that the parties can work together again, because typically they're in the same market.
Geographical area, yep.
Yeah, and then like in a tenant dispute too, if the tenant is still living in the property and the landlord, we don't want it to be an adversarial situation. So once I had this attitude of, when I started a mediation, that I want to make sure at the end we resolve this, but we also can, I don't want to say be friends, but still
maintain a
work
relationship. Yeah.
Right. So once I had that attitude when I started doing this, it really changed the dynamic of the whole situation. And luckily, I've been able to make sure, probably in the last couple of years, every mediation I've done is that they can still work together. So I think that's an important attitude to take. I mean, even with a tenant landlord situation, I would think that the landlord, like you said, giving them cash for keys, if you have that kind of attitude going in, then it's going to have that kind of energy throughout the mediation, even though you're not saying that, but you're thinking that.
Yes.
So I just wanted to point that out.
No, I appreciate
that's
that.
helped me a lot.
I really do appreciate that. I think what you just said, I like analogies, right? So what you just said is kind of that, when they said that people can hear a smile in your voice when you answer the phone, right? It's just that you go into this situation kind of with this attitude of perfect case scenario. Even if they don't settle today, I want to make sure that their relationship is still intact, whatever that relationship might be, right? Whatever it may be, whether it's a working relationship, whether it's a family relationship. One of my favorite mediations was two business partners, and they, business happened, and they lost a lot of money, and so then now they're suing each other. And by the end of the mediation, they remembered that we were friends way before this. Like, our kids are friends. So instead of moving forward with the lawsuit, at the end of the mediation, they both wrote a check for their kids' tuition because their kids go to the same college, right? So it's like, hey, $20,000 check that I would have paid the attorney is going towards my kids' tuition, and that's the ideal, but that still requires both parties to be willing to do that. They came in with an open mind, and then the mediator facilitated a conversation, created an ecosystem where that could happen. So yeah, kind of back to the slide. So conflict is just one of those things. It's inevitable. It's present everywhere we turn around. Most parents that are here could say, "Yep, I've been a mediator before between my kids," right? Or maybe I'm mediating one right now between them. Whether it's the TV remote, whether it's sharing your basketball, whatever the case may be, that's what mediation look like, is facilitating that conversation. And at its essence, what's really happening is competing interests. And I think that was mentioned earlier, to say, hey, just understand what the other party's interest is, and you could realize that, oh, so I can still keep all of my oranges and you can keep all of your apples and we're fine, right? It's once you understand what those interests are, it's a lot easier to find a solution. So while often viewed negatively, conflict itself is not inherently harmful, right? When it's properly managed, it opens up opportunities. And that's one of the things that I always want us to remember when we're dealing with conflict situations, is when properly handled, it drives innovation, strengthens relationships, and enhances organizational performance. So let's run through the 5 stages real quick. Again, today is not designed to give you all the tools you need to become a mediator, right? It's just designed to help us think through why we shouldn't shy away from it when needed, right? One of the main reasons, it's cheaper, right? And because I don't care how rich we are, money is always a limited resource, then we always want to find the best way to minimize cost. mediation does that versus litigation. The confidentiality of it is another big reason. As soon as you file a court case, it's public information. Regardless of what the topic is, it's public information. And of course, one of the third reasons is it's quicker, right? Where the court, by design, might need 9 months, right? 9 months to deal with this. A mediation might be able to be done within a day, and we all find a resolution. So, not trying to create a scenario where we all walk away with how to be the best mediator, but let's run through the stages of it. So stage one is just the opening introductions. We talked about it a little bit earlier, right? Parties will usually complain about the past, okay? The mediator allow everybody an uninterrupted opening statement before asking if there's anything else, okay? And during this process, during this stage, we're listening for what they want, right? They might not say it directly, but they might hint at what they want, right? Listening, what do they want? If necessary, we'll use restatement to ensure that each party hears the other side in a more neutral way, especially if there's a lot of emotions involved. I always like to say it helps to know part of the past, but a good mediator doesn't need to know all the details about the past, because the mediator's focuses on the future and finding a way forward. Okay, so that's stage one, introductions, talking about the past. And then in stage two, we start sharing information and looking for an opportunities for the parties to vent their emotions. Okay, so during stage two, there's going to be a lot of, well, how do you feel about what happened, right? Stage two is usually where we have a lot of the Kleenex, right? Where people are kind of emotional about the past. And one of the things that mediation allows that the court doesn't always allow is for a validation of emotions, right? I could validate your emotions without necessarily agreeing with them, right? Oh, I sense that you're very frustrated. I don't agree with you being frustrated, but I could sense that you're very frustrated. And if I say that statement, then the other side would be like, well, maybe not so much frustrated, just hurt, right? Or whatever it is that they need to say at that moment, okay? But the goal in stage two is to let the parties vent, okay? I like this statement here. Sometimes as a mediator, I can encourage ventilation by allowing a moment of silence, right? That builds tension. So then somebody's like, I don't like that awkward silence, so I'll say what's on my mind, right? So that's a technique that we might use, is just to allow a moment of silence that allows each side to let off steam so that they can be less emotional, especially when we get to phase three. Okay, so phase three is really just about clarifications, right? We've gotten past the emotions, we've gotten past going through what happened in the past. Now it's focusing on what do you want, okay? And of course it has to be within reason, right? But it boils down to what do you want, right? And so a good mediator will probably ask that question a dozen times. Maybe they don't need to, right? Because I've also learned that sometimes a good mediator doesn't have to say much, right? Introduce the parties, remind us why we're here, and then just kind of let them talk. Because like I explained in that car issue, it was because you stopped taking my phone call, right? My engine blew up, you stopped taking my phone call, so I felt like I had no other choice but to get you here so you could hear me, okay? So in stage three, we focus on the present and start thinking about the future, right? We've vented, we've talked about the past. Stage three, we're clarifying what exactly do we want for the future. Okay. This is usually where we start looking for the conciliatory gestures, right? This is where we start listening for, oh, okay, so somebody's nodding yes. Why? While the other person is talking, or somebody said something that shows good faith, right? Shows that, hey, look, I want us to fix this. Okay. So in stage 4, we start dealing with the negotiations of it. Okay. Because the parties are making their own decision, what we do in stage 4 is just create that environment where the parties can brainstorm and negotiate and bargain, right? If I feel like we're still stuck in stage 3 at this space, then I might be asking, how do we reach an agreement, right? I start guiding them through brainstorming. Okay, let's make a list of all the things that we could do to make this go away, and both sides can do that. Okay. Ultimate goal is I need them to generate their own ideas. Okay. I don't need to sell them a solution. My goal is to facilitate a scenario where they can generate their own ideas. So that if at this stage I feel that we're reaching an impasse, because this is where it's most likely to happen. And it might be subtle. It might be that we're going back to a stage 2, or we're going back to stage 1, even though I thought we were already at stage 4, right? So if that starts happening, then I start to think through, what are my impasse techniques? How do I get us past this stalemate? Okay. I'm still asking them, what do you want? How can we reach an agreement? And if none of that's working, we might call for a recess. Let's get you in separate rooms. Let's go take a cigarette break. Whatever you need, let's figure it out. Let's take a break, and let's maybe do a caucus at that point, where we go into separate rooms and I start meeting with them privately, so that they might be willing to share something that wasn't coming out when we were all in the same room. And some other mediators are just automatic putting you in caucuses, right? So some of them will say, hey, look, we'll sit in the same room, we'll do an opening statement together, but as soon as we finish the opening statement, let's separate into separate rooms and start the mediation that way. The ultimate goal for each mediator is to help the clients come to a meeting of the minds. So whatever strategy that mediator wants to use, it's up to them, right? And it might just be a preference for how well the mediator is able to also handle an emotionally tense environment. Okay. But for the most part, for me, I wouldn't call for a caucus until I felt like we were stuck in a stage 4. Okay. And of course, the biggest thing to remember about that stage is, as I'm going back between the rooms, I'm asking to make sure that whatever was discussed, that I get permission before I go discuss it with the other room. And then naturally, we all hope to get to the stage of the agreement writing. Okay. Again, I'm just a scribe, right? I'm just writing what was agreed upon between the parties. So I'm real careful to not put words in their mouth, to the point where I might say, okay, guys, tell me exactly what you want me to write. Okay. And to the point where once that's happening, then I might say, okay, talk a little slower for me because I missed that part. Okay. And if if the parties came with their attorneys, attorneys love this part. They'd love to just write it out. So in that scenario, I shifted over to the attorneys and let them be the scribes. Okay. But bottom line is whatever is being agreed upon, it's being discussed as it's written, right? So that whatever is being written, it's being repeated loudly so that everybody in the room can hear it. Okay. And if we are still in a caucus, then it's still going back and forth to both sides to get their feedback on exactly what the agreement is supposed to look like. One of the key things to remember in the agreement rather is kind of the who, the what, the where, when, how much, but never why, right? Because it's like you don't want to start questioning. You start to sound impartial when you start asking, well, why do you want that? Or why would you take that, right? So almost never why, but the who, the what, the where, the when, how much. If there's a payment involved, is okay. Who's gonna make the payment? Do you know, is it coming from a bank? Is it a check? Is it a Zelle? How much? All of those details so that there's no misunderstanding on what was agreed upon. Okay. So I kept a link here. This is the code that governs. Let's see if I can get the web page, but it's a link and you can click through it when you get the slide deck, right? But this is a section that governs mediations. Okay, Section 154 of the Texas Civil Practice and Remedies Code is what dictates how we do mediations in Texas. Okay, and the red language there is from that section, right? Everything which is said in mediation by anyone must be considered, right? They must understand and trust that their words will not come back to harm them at a later time in order for most people to say the words which need to be uttered to begin the resolution of the dispute, okay? So most states will have a similar statute that governs the mediation, especially the confidentiality part of it, right? And of course, the trigger word there is no information learned in the mediation can be used as long as the information is not discoverable elsewhere, right? So you can't post it on your social media, Facebook page, and then say, oh, you learned that through mediation. No, you posted it publicly. That's how the other side knew about it. Okay, so I think might be able to get us out of here a few minutes early, but I do want to make sure that whatever other question that wasn't thought about earlier that might have came up while I was talking is discussed. You'll have my contact information on the slide deck. And of course, our attorneys make us remind you that the materials for informational purposes only and is not a substitute for the advice of an attorney or a tax specialist. But yeah, but Q&A, yeah.
I just want to, one of the other reasons why I wanted to take this class too is that it's amazing to me how many people don't know that mediation is available to them. The Texas realtors have even emphasized that realtors don't even know. I mean, I can't tell you how many realtors I've talked to that call me about a dispute or something because they know I can handle that, or I'm a broker, and they don't even know that mediation is available to them. I don't know what we can do to get that out other than all of us make sure when you hear about disputes or whatever that they know that mediation is available to them. So I
You're
just
right.
wanted to
Yeah, no, thanks
spread
for
that
sharing
word.
Yeah, no, thanks for sharing that. And I, this is this is us doing our part, right? This is us doing our part. And I think not only do we not understand, or I think the bigger issue is we don't understand exactly what it is. We know of it, we've heard of it. Even my computer, when I type it, most of the time it changes it to meditation, right? I'm like, no, please don't autocorrect me. We're talking about mediation. And so classes like this, we'll keep doing our part to share classes like this. And there was a reason why I wanted to start by differentiating what Judge Judy is doing versus what a mediation is, right? Because people just don't understand. And then some of the people also think that as the mediator, I I'm trying to be careful with my words, but like I'm a judge. No. When the judge orders mediation, it has that weight with the person that's coming is like, hey, I'm here because the judge told me to come see you. So as far as I'm concerned, you're speaking on behalf of the judge, right? But you still have to help them understand that, well, nope. What the judge said is for me to help you guys create a safe environment to have a conversation, hoping that you don't have to go back to him. But if you choose to not settle today, you can go roll the dice, right? I call it Vegas, right? Both parties might think that they're right, but going back in front of that judge is, if you're a gambling man, go for it, you know. But yeah, we'll just keep doing our part to let people know, and it'll look a lot like this, right? Having these kind of classes, and maybe a dozen people at a time will keep seeing the benefits and understanding the logistics of it.
I do have a question.
Yeah.
If they haven't report a complaint to TREC and they are
Okay.
trying to, can I still use mediation with Kathy, or find someone who can help me in that matter?
Yeah. 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 And that's part of what I kind of call that EDR, early dispute resolution. So at the end of the day, what you're wanting to do is just address any misunderstandings as soon as possible. So you don't need to wait for it to be reported to TREC. In fact, it might not ever get to TREC, but that doesn't mean that it's not a conflict. So yeah, in that scenario, it might look something along the lines of you show up, right? Well, here's what we would normally do in that scenario. They're the plaintiff, right? You're in a situation, you're minding your business, you get a lawyer from there, you get a letter from their lawyer, okay? Depending on what the letter says, it might be a demand letter that says, hey, give us A, B, C, or else we'll avail ourselves to whatever the court will, to the law, right? So in that scenario, you might just reach back out to the letter to the lawyer to say, hey, got your letter. I want to recommend a mediation before this thing goes any further. So that's kind of scenario one. You get a demand letter and you respond by saying, let's sit down, let's figure this out, okay? Scenario two is you get a lawsuit. So maybe they didn't send a demand letter, they just sued you, right? And then you have to respond to that lawsuit within the required amount of time, right? But even in that scenario, you could go and say, hey, me and my attorney would like to figure out a time for us to do a mediation before this issue goes any further. And it's not you showing any kind of weakness. Nobody at mediation, it doesn't mean you're sitting around singing a kumbaya. No, it's still you showing that, hey, all the things that you're saying, I hear you, but here's why I don't agree. And yes, you could show your facts at that point, right? The lady that I was saying at the beginning of the class when I said she had the septic issue, she keeps all of her text messages in a software. So she showed all of these facts. And if she would have went to mediation, both sides would have seen that, oh, I picked the wrong fight. I got the wrong person. She's not an easy rollover like I thought it was going to be. Okay. So even though you're not there to fight, you're just presenting the facts to say, I don't need this to go. I don't think you guys want to go to court. Here are the facts. Let's talk through it. So yeah, short answer is no, you don't have to wait till it becomes a problem to get a mediator involved.
Thank you.
Yeah. Yeah, and like I said,
Every
Elizabeth,
every
did you take
contract in every contract in the state of Texas has a mediation clause in it.
everyone, yep.
Elizabeth, did you take pictures when you moved in of how it looked?
Well, it was my property, so it was listed, and the pictures just were there in the MLS, and I took pictures when we moved out.
Okay, that's proof of what it looked like before it moved in versus when it moved out. So if they did damage, then the damage would show up while they were in it.
So Kimberly, I think the issue was it was almost more of a final walkthrough type issue, where we could say maybe an exclusions versus final walkthrough issue, where after she moved out, then the buyer said, hey, I expected all of the couches to still be in there, right? And so part of the conversation here might just be able to distinguish versus real property versus personal property versus, I think that's more of your issue is no, only the fixtures and the real property was being transferred, unless there's an exclusion somewhere that you guys agreed upon. And then, of course, part of the conversation too is at some point they did a final walkthrough, right? Maybe before closing, in this case, because you had was that a 90-day lease back, you said? From October
Yes.
to January?
Mm-hmm.
Yeah. So on the lease back, then they had the right to do a final walkthrough when they became your landlord, right? Because at closing, the relationship shifted, and the temporary lease agreement says starting on day X, now you're the tenant, even though it's your property, and they're the landlord, right? So anyway, that's the crux of the issue is who's the landlord, who's the tenant, and what is normal wear and tear, what is a fixture, what's not. Yeah, we could like I said, you'll have my contact information, but we could take that offline and just kind of talk through what it might be a money grab. It might just be that they were upset that your husband didn't clean the yard as well as they wanted him to. It might be something that I don't want to use the word trivial, but it might be, okay? And it's just a matter of everybody taking a deep breath and kind of talking through it. Brought you guys back a few minutes. I'm still here. I'll field any questions, but thank you all for your time. Hopefully this was as engaging as you wanted it to be. Once you'll get an email with the slide deck. Feel free to reach out with any other questions or thoughts or comments, and hope to see you guys around in the future.
Hey, Damon, I just had a quick question.
Yeah.
You mentioned during the slide deck that you have impasse techniques when you get to like how to break that impasse. Can you just share just a few of those techniques that you use?
Yeah, absolutely. So it's in stage 4, and I pulled this slide deck back up here, but it might just be calling for a recess, right? So that once I see that we're kind of stuck, it might just be I might just mean it's time for snacks, right? That might just be time for a bathroom break. go outside, stretch your leg, because my default mediation is about 4 hours, right? And to put that in perspective, we've already been at this conversation now for 2. So it's like by the end of the second, you're ready for a break. By the end of the second hour, you're ready for a bathroom break. You're ready for this break, that break. So that's one of the main techniques is let's take a recess. The other is let's separate into different rooms. So if I'm doing it via Zoom, I might do breakout rooms where I put party A in room A, party B in room B, and if there's a third party in the third room, and then I start hopping in and out of each room to see if we can get more conversation going. And those 2 usually work. Right?
My second question is I tend to work with a lot of people who are getting divorced, and they will ask me, what do I need to know about mediation? How, like, any advice? And I typically tell them, know your non-negotiables, but know what you're willing to give before you ever walk in the door. But what would you say to somebody so that they're more likely to have a successful mediation experience?
Yeah, in divorces, what I've learned is you have to be kind of patient, because there's always the one person that wants that divorce more than the other. Always. They could say, oh, it's mutual, but there's always one person that wants it more, right? So that's probably who reaches out to you first, right? And that person's like, can you call her or can you call him? And it's like, no, they need to call me, right? In that environment, I want both parties to reach out to me, not one of them trying to get me to reach out to the other one. Okay? And of course, depending on the role you wear, especially as a realtor at the table, you're like, hey, look, I'm not gonna wait because they might call somebody else, whatever, right? But to have a successful mediation with that kind of tension, the divorce tension, it's important for the both of them to get to a place where they want to use mediation, not just one person trying to push it down the other person's throat. And what I also always remind them at the beginning is this isn't a place for a fight. If you guys are looking to fight about things, go back to the courtroom. That's not what I want, right? But at this table, what we're trying to do is iron out the important things. So in that scenario, I might start by saying, okay, guys, what do we want to talk about first? The kids or the money, right? And that kind of sets the tone, right? Usually there's kids involved. If there's not, then it's like, okay, we don't have any kids to talk about. Let's talk about the stuff, okay? And so even the ones that say, oh, I don't care, she can have the house. Well, that's fine. Let's talk through that. Because depending on the age of the people getting a divorce, inevitably somebody will remarry, right? So you say keep the house, but I might need you to get out of my name within X amount of time so that I can go buy another house. So all of those different pieces are what I would focus on in that scenario. Is just one, both parties need to call and reach out so that it's not just one person pushing this thing on the other. And then the other one is having that system in place to say, okay, guys, what do you want to talk about first? And kind of let them have control of the conversation. I don't care what you guys want to talk about first, because we have to talk about both of them anyway, right? Who's going to have the house? Who's going to have, whether it's, we call it primary or joint custody, whatever it is in that, what language you want to use, that part of it.
Got it.
Yeah.
Okay, thank you.
Yeah, absolutely. Like I said, feel free to tap out if you don't have any more questions, and I'll just hang out for any other feedback, thoughts, and questions. Let me put my contact information up here.